Hello students, let's talk about what everybody else is talking about. That is the new criminal codes that has replaced your Indian Penal Code, Evidence Act and Criminal Procedure Code, that is your CRPC. Now it's very important topic, not only for the sake of understanding, because it's a huge change. As a citizen of India you should be aware about that what are the things that are happening. We had this IPC of 1860, we had these criminal procedure code, we had this evidence act. These are the British colonial, the very old 150 years old acts that have now been replaced. Now we have new acts in place of that. So it's very important to understand the significance of it, the things that are new now, the things that have been changed, and for the purpose of your examination also, for the law entrance examination, the kind of things that can be tested as far as these new criminal codes are concerned, the passages that you can come across, the kind of knowledge that can be tested in the upcoming examination. For all these purposes, this is a very important topic that you should be aware about. Now before starting, let's everybody be on the same page regarding the categorization of laws. If we talk about in these terms, that is your Indian Penal Code, your Criminal Procedure Code, and your this Evidence Act, you can categorize it in terms of, say, substantive laws or procedural laws. Now CRPC, Criminal Procedure Code, as the name itself suggests, has a procedure in it. It's a procedural law. It tells the procedure about how to go about things after you know the definition of a crime, after you know the punishment for a crime, and then there are steps about admissibility of evidence that will be dealt under Evidence Act. Then there will be a procedure that will be followed, procedure for arrest, procedure for so many other things. So every law has its own specific purpose. The substantive law, that is your this Indian Penal Code that we had 1860, that will define the crime, that prescribes the punishment. This is the definition of murder, or this is the definition of theft, or this is the definition of robbery, extortion, or whatever offense you can take. It will define it properly, and then it will say that if you commit this, this is the punishment, this much fine or imprisonment, or even death penalty in certain cases, or life imprisonment. So definition of crime, punishment, that is the domain of substantive law, which is your Indian Penal Code. The procedure that will be followed, that is the domain of your procedural laws, which is your Criminal Procedure Code. And the admissibility of the evidence and other aspects of it is your that will be dealt under Evidence Act. So this is how we were doing things so far. Now things will remain the same, but the names have been changed. Certain new things have been added, adapting to the new technology, adapting to the changing modern society, adapting to getting rid of some of the colonial terminologies, colonial mindset, colonial era, the intention with which those laws existed, that was essentially to exploit the Indians rather than give justice to them or serve them as a lawgiver. So that intention, that those things have been changed. The intention was to revamp it, Indianize it essentially, as you can also see from the name also. So instead of calling it IPC, the new act will be called as Bharatiya Nyaya Sanhita. Now, as you know, Nyaya means justice. So earlier it was penal. That penal means punishment. So the focus was on punishing the person. Now the focus is not on punishment. The focus is on giving justice. So justice is a bigger term, justice is a higher term in the sense that, and like the speech if you have followed in the parliament that was given by our Home Minister Amit Shah, he quotes and cites a lot of Indian lawgivers who always put justice at a higher pedestal, and punishment was not the main motive, was not the main intention behind making a law. So that is one thing, that philosophical and ideological changes, that is also one very major aspect of these changes. And in addition to there's a lot of other things. So number one, try to remember these names, because these are slightly different sounding name than you are usually used to in as far as other where acts are concerned, laws are concerned. So Bharatiya Nyaya Sanhita. I mean, it's written bill here, but it's no more a bill. It's act now. Bharatiya Nyaya Sanhita. So Nyaya is justice. So it's a Bharatiya Nyaya Sanhita. Then Bharatiya Sakshya. What is Sakshya? Sakshya is evidence. Sakshya is sabut. So Bharatiya Sakshya. So we have Sakshya, that is evidence. We have Nyaya Sanhita, that has replaced your Indian Penal Code, and Nagrik Suraksha Sanhita. Now this Nagrik Suraksha is again something that has replaced your existing CRPC, that is your Criminal Procedure Code. So Nagrik Suraksha has replaced Criminal Procedure Code, Nyaya Sanhita has replaced Indian Penal Code, and Sakshya Act has replaced your Evidence Act. So please keep this absolutely clear and do not get confused, and there should not be any confusion because it's quite obvious. Nyaya has replaced punishment, Nagrik Suraksha has replaced procedure, and Sakshya is evidence. So these are the three new acts that you should first know the name properly. There should not be any confusion in that. Now moving forward, the new codes, as we saw, these are the three, and finally the one that got the assent of the president, it's called Bharatiya Sakshya second bill, got the assent of the president, because once the first was introduced, so many objections happened, so many changes were required, so many suggestions were taken, and that was ultimately modified, and a second bill was tabled. So be it Sakshya, be it Nyaya Sanhita, be it Nagrik Suraksha, you will see the word second here. So that was the one finally that got the assent of the president. So we have this BNS, BNSs, you can remember like this for the sake of convenience. Aim, I told you that number one aim is to replace the colonial era. And if you have heard the speech of the Home Minister in the Parliament, he cites a lot of examples where the British era terminology was used, like British Crown, Her Majesty, and so many things that has no relevance now. So now that we are independent, and it's been almost 75 years of our independence, so these words don't need to be in our laws, right? So that needs to be replaced. That is what has been done, that on the surface level, on the preliminary level. Then the intention with which these laws were made, the intention was to control the citizens of India, the people of India, essentially, when Britishers were there, to make sure that there is no revolt, to make sure that there were provisions like sedition, there were provisions like essentially the intention was not to provide justice, the intention was not to provide a good governance as such, but to keep them in control. So that intention, that motive has also been revamped, rebranded, reframed, or whatever word we can use for these new acts, as we can see in the changes. So we had this Evidence Act 1872, we had this Indian Penal Code 1860, we had the Code of Criminal Procedure 1973. So 1872, 1860, 1973, these were really old laws that needed change, that needed replacement, that needed this kind of rebranding, if you can say. However, it's not that we were using the 1860 Act as it is, or 1973 or 1872 as it is. Every now and then there were so many changes, so many amendments, so many things were done to adapt it to the modern changing society, be it cybercrime, be it so many other things. But of course, essentially, no matter how much you suppose you have a torn cloth, no matter how much you stitch it, it will only be an old cloth. But if you get a new cloth, that's a different thing altogether. So instead of making amendments again and again and trying to fix things and delete things, it was better to have a proper new Indianized law that not only shows the philosophy of India but caters to the needs of the modern society and the Indian needs that are required in this time, in this era. So that essentially is the outline, basic structure, basic thing about it. Starting with the first major act, that is your Nyaya Sanhita, which has replaced the erstwhile Indian Penal Code. So of course there are so many other changes, as you can see here. One of the significant changes is that terrorism has been defined and added as an offense. So several things that were not directly as an offense, but they, we used to interpret the other offenses and put those things in those offenses. Now instead of doing that, we have given exclusive attention to certain specific things like mob lynching. Very important. So many cases of mob lynching was seen, in the recent past, or like for a long time now. So as far as mob lynching is concerned, there was no law defining mob lynching. What is mob lynching? Now we have a proper definition. Now we have a proper offense that called mob lynching. And if you have been following the previous year CLAT papers, in CLAT 2020, there was a question from mob lynching. So mob lynching has been introduced as an offense. Organized crime has been added as an offense. Then that includes offense such as kidnapping, extortion, contract killing, land grabbing, financial scams, cyber crime, carried on behalf of cyber syndicate. All these things, the new things that have been added. Then sedition, very controversial. So many judgments from the Supreme Court, from the public in general, has talked about sedition. Do we even need to retain sedition as an offense anymore? Because government is by the people, for the people. Why do we need some? Even if I show dissent against the government, the ruling government, why should I be imprisoned for that, or why should I be penalized for that? So sedition as an offense has been removed. However, it does not look, it's not how it sounds. Another provision has been added that is similar to sedition. Of course, you cannot say something that will be a threat to sovereignty of the country and security of the nation. I think that has been taken care of. So the sedition as an offense has been removed. However, the provision on endangering the sovereignty, unity and integrity of India and other aspects have been introduced in another way. One more important aspect is community service has been added as a form of punishment. You see, it's not always necessary that someone is guilty of an offense. He has to pay fine, or he has to go to jail, that is imprisonment, or in cases of very serious offenses, even life imprisonment and death penalty. Now there is one more aspect to it, there is community service. You committed an offense, now you go and do some community service, like you do something for the society in the sense that benefits the society, and you also emerge as a good citizen. You coordinate with other people and help other people. So that's a very good alternative, and it's a foreign concept. It's very popular in the Western countries, where people who have committed not so serious offense, they are given a chance to reform themselves by sending them into the society and making them work for the society, so that they come out as a changed individual, and also contribute something out of that, the whatever thing happened. So it's like a good way to not only keep them under control, but also give them an opportunity to give back to the society, irrespective of the offense they have committed. So these are the some new changes that looks exciting, looks new, looks gives a different vibe to the existing the earlier Indian Penal Code. Then we have this Saksh bill, not the bill, I mean the word bill is written here, but now that you know that it is an act now. So this Saksh is, as far as evidence is concerned, of course one of the important thing about evidence is, with the evolution of technology, we have internet, we have so many things, we have artificial intelligence now, there are so many cases of, say, this deep fake, and so many new types of crimes are happening that were not even imagined earlier, that the people could not even conceive this idea that this could also happen when we had this earlier Evidence Act. So of course so many new things had to be added. So we have this classification of electronic records and documents, and it includes information stored in semiconductor memory or communication devices. So many things about regarding the videos, regarding the electronic oral evidence, regarding the comprehensive certificate of submitting oral evidence. Secondary evidence includes now oral and written admissions, testimony of a person who has examined the document, whether he is skilled to examine the documents. All these things have been taken into consideration, whether something could be admissible in a court of law or not, as far as deciding the guilt of the person is concerned, or in any trial, what are the admissible evidences, what are whether it can be considered as an admissible offense. All those things have been taken care of, taken into consideration, and a lot of changes have happened in the Evidence Act as well. Then coming to the Nagrik Suraksha, that is to say your criminal procedure, the Code of Criminal Procedure. Here Nagrik Suraksha, this again, now this allows the use of handcuffs by police officer. In certain cases police can use handcuffs, that is one thing. Police officer can request medical examination of accused in certain cases, including rape cases. Magistrate can order any person to provide finger impression and voice samples. Of course that is to facilitate the procedure, that is to facilitate the process. Then we have the provision has been taken for speedy trial. That is the main motto. The justice delayed is justice denied, as the principle says. So the procedure should be simplified. There should be timelines. There should be a time limit, that okay, charge sheets should be filed within 180 days, or fix a time, so that things do not exceed unreasonably for a long time, and the people are going again and again to the jail, as this Tariq pe Tariq philosophy of the old Indian courtrooms, we had the image that we have. So to fix those things, we have these speedy trial. The attempts have been made to fast forward the whole procedure, as it is a procedural act. And similarly, so many other changes have been made. So that was essentially the broadly I've told you. Of course there are so many changes, so many sections have been changes, modified, some deleted, some added. I'm not getting into the detailed analysis of all those things, and as a law aspirant you don't need that much detail. Of course for a judiciary aspirant, for other especially for lawyers and other people, law students, they will be getting into detail. But a basic structure, basic outline, basic thing that you should be aware about, these are the things. And of course you can read more about it. We will keep giving you inputs in our classes, in our handouts, in our discussions about it. Finally, let's just quickly talk about, was it needed, and what are the good things that came out of it, and what are the criticisms of it. Now instead of bringing the new laws, couldn't we just make amendments to the existing laws? I've already addressed this, but I'll say it again, that number one, the mindset of these 1860 and this 1972, the words, the terminologies of the British colonial era, that mindset of the British colonial era, that needed to go. So that is one thing, that a fresh act was required. And instead of making so many changes and interpreting, and that it was very unstructured, very complicated, now it has been simplified, it's more structured, so it's easy to navigate, it's easy to find the definitions, and of course the new things that have been added, like mob lynching and other the cybercrime related provisions, that are easy to locate with a specific sections at appropriate places. So of course it was definitely the need of the hour that we have these new things replacing that. There are so many criticisms also, that okay, of course the opposition will definitely criticize, saying that what was the need of it, we already had it, and that was more comprehensive, and you could have done it easily instead of going all these ways. So there is counter argument to all of that. Some of the arguments from the other side might also have some merit, but now that we have it, so let's focus on the changes that have been made and how it is beneficial and how we can use it. One of the challenges that can be faced is of course the implementation of these. So there are many cases, pending from several years. So now that are being dealt under the old laws. Now when the new laws will be implemented, how will we balance those, you see? So will we transfer the existing cases to the new laws, or the new laws will be applicable to the older cases? How do we demarcate that? How do we separate that? And will the justice be served if we treat it differently? So that is a challenge that will eventually see how it turns out, and how we find a solution to it, or how sort things out. Of course it's not a major problem. Of course there will be things like we already have some established principles like retrospective laws and things like that, so that will be taken care of. So yeah, that's about these new laws, and I hope you learned something new. I hope it was helpful. With this, I'll take your leave and see you in the next session about other aspects, about other things, and we'll keep coming. Subscribe to this channel and share this video with all those people who are interested in law entrance examination, or knowing about these new laws in general, because everybody should know about it. And thank you so much. See you again.